Hello?
Oh, she said that sound.
Okay, wait a minute. Why? My wife comes and send a message. Your face is going to move. Hello? You know, what's happened?
It's your chance, but who's be a quiet say what? I did say,
besides, friend of friend, I'm so years. No, I was not testing messages here. And our office also, I'm still like Diana. She says, I
mean, so we a guy man, and may young who could look cry. And also wants a family drilling company limited for Kana.
What's it then? Family Drilling Company Limited.
Ye two borehole, biofuel, biogas, swimming pool, plumbing works in Naso, ye be, Frey 0240 333 111, and that's 0244 144 822.
Me and Pa and you want swimming pool me see. Me want to you be here. Family drilling now. Family drilling.
What fashion yala shit?
Me out that shit.
Good evening and welcome to Hot News. We are live on Pan-African Television. We are also live on Facebook at Pan-African Television as well as YouTube at Pan-African Television. We are also streaming on about 48 African countries. You can join in the conversation by sending in your views, comments and contributions on our WhatsApp text line displayed on the screen. We'll make a time and read all those out for you. You can as well share the Facebook Live for other people to also watch tonight's edition of the program. Just subscribe to our page on Facebook, like our page, and of course, you'll get our notifications and watch all our programs. Tonight on Hot News, we are looking at the decision arrived at by the Supreme Court on the voting rights of a deputy speaker. You know that the Supreme Court has ruled that it has not been provided for in the Constitution expressly that the deputy speaker or a deputy speaker who is a member of parliament cannot vote. A private legal practitioner sought to get interpretation for Article 102 and 104 of the 1992 Constitution. 102 talks about forming a quorum in parliament, and 104 talks about voting on the floor of parliament. The Supreme Court says the decision by parliament to deny a deputy speaker who is also a member of parliament from voting would amount to disenfranchising the constituents of the said vote. Do you agree with that? However, this didn't go down well with the minority in parliament. They have described the judgment as a judicial support for the approval of the e-levy. They've also said that the judgment was a travesty of justice or a travesty of parliamentary justice. What does that mean? Well, we have Member of Parliament for Bosa North constituency, Honorable James Agaga, with us in the studio. We'll delve deeper into the provisions in the Constitution and then their standing orders as well to see whether the decision arrived at is a right decision or not. Honorable, good evening. Thank you so much for joining us on Hot News.
Thanks for having me.
My first question to you, why would you describe a decision by the Supreme Court, a very independent institution, as a travesty of parliamentary justice, a support for the approval of e-levy and a partisan decision? Those were the words used by the minority in parliament.
Well, Justice, first of all, we need to contextualize what the minority group or the minority in parliament said in relation to the Supreme Court decision. Here is parliament, one arm of government, and parliament itself is a creature of the Constitution. For well over 30 years, starting from 92, when the current constitutional dispensation was adopted, we have Parliament has been regulated by its own standing orders.
Okay.
And it is the Constitution itself which allows Parliament to adapt for itself the standing orders to regulate its procedures. we've lived with this for so long a time. We never had challenges until quite recently when the Supreme Court, made that incursion into the internal procedures and practices of Parliament. This is the Supreme Court. They have interpreted Article 102 and 104. And the controversy in Parliament clearly revolved around those two provisions of our Constitution. Now, our position has been very clear that the events leading to the first Deputy Speaker of Parliament, who counted himself as forming part of quorum for purposes of taking a decision, for purposes of being counted, even under Article 102, was unconstitutional. But the interpretation of the court is that there are two thresholds. One under what Article 102, which is the threshold for business before the House to commence. And that there is yet a second threshold provided for under Article 104, which is that half of the members of Parliament present and voting. Right. So they sought to draw the distinction. And then came to the conclusion that whatever happened in Parliament, where the Deputy Speaker actually counted himself whilst in the chair, was proper and constitutional, and that our own standing order 109, which expressly
1093 or 109.
109. I mean, we can 1093.
1093.
Yes, because 102 deals with a different matter. But the very specific order is 1093, which is very clear that a Deputy Speaker or other member presiding shall not retain his original vote while presiding. Justice,
the Supreme Court thinks that contravenes the Constitution.
I have read the judgment of the Supreme Court, and when you go through the judgment, you can tell that the Supreme Court itself had a lot of difficulty, especially when it sought to state that, look, those making the case that Parliament is master of its own rules and that the judiciary cannot make incursions into what is supposed to be theft that Parliament ought to control, advancing an argument which in their own estimation would amount to an introduction of the political question doctrine into our body politic. Then they go on emphatically to state that such a doctrine is alien to our own constitutional dispensation or order, if you like. But the problems I have had with this reasoning is that if you just oppose that against decisions of the Supreme Court itself, previous decisions, such as to for an Attorney General,
very well,
you are unable to come to terms with the incursions the Supreme Court has now made into what we thought was the domain of Parliament. Its ability to regulate without any hindrance its own internal procedures and to make determinations on matters that come before it. And to for an Attorney General was very clear that the courts themselves should not and ought not make those kinds of incursions. At the same time, the court did not make a conscious effort to distinguish, even though they cited to for an Attorney General, but going through the judgment, they only cited to for an Attorney General in laying out the principles of interpreting the Constitution. And for an Attorney General, it's about the locus classicus when it comes to, the position of the law on the interpretation of the Constitution. They cited that decision in respect of that particular matter. But in making a clear-cut distinction with respect to what is stated in there, right? And I tend to see some element of the so-called political question doctrine being espoused in that particular decision. And yet that effort was not made to distinguish the reasoning of Justice Appiah when he said that, I mean, the courts cannot inquire into the legality or illegality of what happens in Parliament. But what the Supreme Court did was to delve into matters that actually happened in Parliament when the first Deputy Speaker counted himself and actually...
But the Supreme Court is not, bound by its decisions. They can change.
Yes, but that is true. That is true. That is true. It's not bound. It can actually, make rich decisions. Exactly. That contradicts its own previous decisions. And when that happens, of course, the latest decision would hold sway. Right. But the point I'm making is that in so doing, normally what they do is that they will try to distinguish. Right. And to explain why the previous decision should no longer have any efficacy. That, in my view, was not done in this particular judgment. And that is where I have a challenge. So when law students read for an Attorney General and read the decision that has now been handed down by the Supreme Court in relation to Articles 102 and 104, they are bound to suffer some confusion in their mind. Just as I have a problem comprehending how for an Attorney General was distinguished. I didn't see that in the judgment. Right. And so, whichever way you look at it, our position is that parliamentary democracy in our country has suffered a jolt. Because you have the situation whereby one arm of government, which is supposed to be co-equal, never mind that the power to interpret the Constitution is vested in the Supreme Court.
Power to interpret the Constitution?
It is vested in the Supreme Court, but you see, this is a power that ought to be exercised very carefully, especially when it has to do with matters such as the standing orders of Parliament.
But they are saying that with the standing orders, I mean, the Constitution gave you that blessing, of course, at Article 110, I think so, that Parliament would probably have a standing order which will regulate, your activities and all. But that being said, the Constitution is your boss. So any order you make, if it contravenes the Constitution, that is void. True or false?
Well, that statement is true, but to what extent can you say that the standing order which has now been impugned,
the one struck out,
standing order 109.3, sins against the Constitution? To what extent? When Article 102 is so clear and emphatic, because what 102 does is to exclude whoever is presiding, whether the person is a member, an ordinary member, or one of the deputy speakers, right, from being counted for purposes of quorum. Now there is a distinction which has now been made by the Supreme Court that there are two types of quorums. Yeah. The first is for purposes of the commencement of business, and the second is when a decision is about to be taken. I find it difficult to understand that distinction, because what do you think informed the decision of the framers of the Constitution to exclude the person presiding whether he's a deputy speaker or an ordinary member, from being counted for purposes of quorum for commencement of business. Then you turn around and say no, but for purposes of being counted for when a decision is about to be taken, that is the second quorum that they talk about, the one presiding, if he's an ordinary member or is one of the deputy speakers, that person can actually be counted and can vote.
Why do you also think that the framers of the Constitution have been very silent on forming a quorum to vote, but they were very clear on forming a quorum to commence business?
Well, so that is why I thought that we should have the article, the construction of Article 104 should have been influenced heavily by the express words and the exemptions or the exclusion created in Article 102. But unfortunately, that was not the reasoning of the Supreme Court.
Okay.
But you see, Order 1093 sought to give clarity to the matter when it expressly excluded the deputy speakers from voting.
Right.
Okay. Now, that particular standing order should not even be considered in isolation. And what the court did was to consider that particular standing order 1093 in isolation. Why do I say so, Justice? If you look at order 211 of the standing orders, order 211 has this to say. Let me read this for purposes of clarity. The chairman, and here we're talking about committees.
Right.
And remember that the chairmen of committees are also members of parliament.
Right.
They've been voted for. They also represent the constituencies, just as the second deputy speakers.
Right.
So the logic espoused by the Supreme Court should necessarily affect this standing order 211, because what that order says is that the chairman shall not have an original vote, but in the event of an equality of votes, he shall give a casting vote. So when the chairman is presiding at the committee's meeting, no.
When there's a tie,
let's draw the line.
Right.
But he does not have an original vote.
Right. I accept.
Okay.
Agreed. Yeah.
He does not have an original vote. It means that when the committee commences business and a division is called, all right, for a matter to be determined by voting, he, the chairman, who is himself a member of parliament, does not vote from the onset.
Right.
That is why the wording is original voting. He does not have an original vote. The only time he can vote is when there is a tie. Then he comes in as some appellate authority to determine the matter, because there is a tie. Now here too, Justice, would you say that by taking away the original vote of a chairman of a committee, this particular standing order is also unconstitutional? And so the point I'm making is that if the Supreme Court had taken pains to go through the standing orders in its entirety, they probably would have come to the realization that standing order 109, all right, sought to give some meaning and add some flesh, make it very easy to comprehend what was contemplated under Article 102 of the Constitution. But unfortunately, that was not the thinking of the Supreme Court. The Supreme Court said there was a threshold for purposes of quorum, and then went on to strike down standing order 109. Now, how about standing order 211? As I have explained, because the chairman of a committee is also a member of parliament.
Maybe that wasn't in contention.
It wasn't in contention. But, well, I thought that we were dealing with constitutional interpretation here. And so once you interpret Article 102 and 104, and you come to the conclusion that the deputy speakers can actually be counted for purposes of quorum in the second instance under 104, and that they can even vote, and for which reason Standing Order 1093 would be in contravention of those articles of our Constitution, then necessarily they ought to have adverted their minds to what is also captured under Standing Order 211. But you see, I'm sure the Supreme Court had a challenge.
Right.
Because if they did that, right, the incursion we are talking about would have become so palpable for all to see. They would have, in a way, reviewed or revised the standing orders in a manner that some would say is far-reaching. And that is the problem they sought to avoid by limiting themselves to just one standing order. But if they had applied their own logic, the logic which informed their decision to strike down 109, then necessarily they ought to have impugned 10211 as well.
Let's get into the reasoning of the Supreme Court justices. According to them, before a deputy speaker of parliament was a member of parliament, meaning before whoever became a deputy speaker of parliament was a member of parliament, is a member of parliament. And a decision by denying the person a vote on the floor of parliament amounts to disenfranchising the constituents of that member of parliament.
Well, once again, Justice, this is the reasoning of the Supreme Court that we are bound to follow. But I have serious challenges with the reasoning contained therein, I mean, in the decision. Because, look, if you say as deputy speaker, by virtue of being elected and represents a constituency, must at all times have the right to vote. You must also understand that the moment you accept to be nominated as one of the deputy speakers and you are elected in the process, that position comes with some privilege, some responsibilities. So in one breath, you cannot accept to enjoy the privileges that come with the position. For instance, you, when you are in the chair as a second deputy speaker, you exercise the rights of the speaker. You make rulings. You are accorded some courtesies by ordinary members. When you are speaking, an ordinary member who is on his feet must resume his seat. You even give rulings, and yet you are a member of parliament yourself. You may not be knowledgeable in, say, your understanding of the standing orders or even the constitution than other members. But the mere reason or fact that you find yourself in the speaker's chair instantly elevates you to an exalted position, and all others must respect that. So when you now occupy that position, one, you are expected to be neutral in allowing the debate to flow. You are expected to be unbiased. And so if you are in that position, and the logic is that, listen, because you are also a member of parliament, you can vote. But why is it that if you can vote, you cannot partake in the debate? So if we stretch the matter, I mean, in that manner, then somebody would say, by parity of reason, you should be allowed to take part in the debate as well, because you are a member of parliament for a constituency. So when other members are debating and you are in the chair, you should equally be given the opportunity to be heard as to why a certain position should hold sway over some other position that may have been canvassed by MPs from the opposing side.
Right.
So you see, if you stretch this matter for justice, one would say, okay, maybe the framers of the Constitution made a mistake when they allowed deputy speakers to be elected from amongst members of Parliament. But I don't think so. And that is why I thought that Article 102 should have had a lot of influence in our construction of Article 104. But unfortunately, that was not done. And that is why we think that the incursion by the Supreme Court into parliamentary practice and procedure has created a lot of problems for the legislature. And now, moving forward, we're going to have challenges. So some members are of the view that, well, if this is the logic reasoning of the Supreme Court, so should we continue to accord courtesies to a deputy speaker who finds himself in the chair because the speaker is unable to preside? Of course, you cannot assert all the rights that ordinary members would have ordinarily, right? When you become a deputy speaker. If you want to do so, then we would also take it that, listen, we have equal rights.
Right.
We have equal responsibilities. So if I rise, I'm on my feet, and you try to shut me up, I would simply just disregard you and treat you as if you are an ordinary colleague of mine. That is going to create problems for order in the chamber or in the House of Parliament. And that is why we thought that the Supreme Court's decision is a blow to parliamentary practice and procedure.
Now let's look at the articles in contention, those that the private legal practitioner went to seek interpretations for. 102 says a quorum of Parliament, apart from the person presiding, shall be 1/3 of all the members of Parliament. Apart from the person presiding. It could be anybody in the absence of even the two deputy speakers. I mean, a member of Parliament could preside, true or false. So apart from anybody presiding, the quorum shall be 1/3 of all the members of Parliament. But if you come to 104, it says, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting. Majority of members present and voting, with at least a half of all members of Parliament. With at least a half of all members of Parliament present. And then 2 says, the Speaker shall have neither an original nor casting vote. Now, if you look at 1041, all members of Parliament present and voting. The Deputy Speaker is a member of Parliament present at the time of voting. One would have asked, a member of Parliament who is not the Speaker, because the 1042 laid emphasis on the Speaker. The Speaker shall not have neither an original nor casting vote. If you look at the reason of the Supreme Court once again, they said it has not been expressly provided for in the Constitution that a Deputy Speaker cannot vote, especially when it comes to Article 104.
But that is where I thought that we should have done some distinction. Nobody is saying that when you become a Deputy Speaker, your right to vote is taken away all of a sudden.
Right.
You continue to reserve that right. But you see, we're saying that the only time you must not exercise that right is when you find yourself in the chair. Because when you find yourself in the chair, you are supposed to hold a certain balance. You are supposed to be neutral. You are not supposed to even partake in the debate. And yet one of the core functions of Parliament is to deliberate on issues that come before it, issues that are of public importance. So if the position is that the moment you find yourself in that chair, you are precluded from debating, joining the debate, you must only sit back and regulate the conduct of members, give rulings where necessary. Why do you think that when you are in that chair, because it has not been expressly stated that you cannot vote because you are also a member of parliament, we must extend that right to you? And that is why I said that the reasoning of the Supreme Court now, if you stretch it, it would mean that second deputy speakers or ordinary members presiding can also assert a right to debate. And if they did that, I mean, how would you fall them in light of this the recent ruling by the Supreme Court? And that is where I think that it's going to be challenging for Parliament moving into the future with this, I mean, decision of the Supreme Court. So nobody is saying that second deputy speaker cannot vote. We're saying that the only time you must not vote is when you are presiding. Or as Article 102 has stated, if you are in the chair, don't be counted for purposes of quorum. But where I have a difficulty is when Parliament commences business and a second deputy speaker in the chair has not been considered for purposes of quorum. You are not going to adjourn and come back. Sometimes you sit from the beginning, take decisions before you adjourn. So proceedings are held continuously. So at what point would you now draw the line that having not been counted for purposes of quorum, the 1/3 quorum that is envisaged under 102 of the Constitution, when it is about time for a decision to be taken, you would all of a sudden, having not been initially counted, would now be counted. You now be counted for the second quorum under 104 and then be allowed to vote whilst in the chair.
Is the quorum for...
Okay, so let me give you an example. When the voice vote is about to be taken, okay, members are the ones who would scream. All right?
Right.
In favor. Or if it's against, you scream nay.
Yeah.
Aye. But in the course of doing that, because the voice vote is one way of voting, the second deputy speaker or a member presiding would normally not take part in that. They are mute. And they must be attentive to be able to determine whether it's the ayes which is more thunderous or the nays.
Right.
Okay? Now, when the voice vote is taken and a member feels dissatisfied that, okay, the voice vote is inconclusive, it doesn't determine the outcome properly, and so you want a head count. At that point, we're saying that the speaker, having not taken part in the voice vote, should now step down and be counted. That is what the Supreme Court decision would now require us to do. But that is problematic, because the voice vote, when it's taken and there is controversy and a division is called, you are saying that let's count those who voted by voice. But remember that the speaker, the second deputy speaker, would have been sitting in the chair and not taking part in the voice vote. So what happens? So when you now count him, how do you reconcile that?
But the Supreme Court has distinguished a quorum formed under Article 102 from that of a quorum formed under Article 104. Why would that want to link a quorum formed under Article 102 to that of the one under Article 104?
Yeah, so that is why I have explained. I have explained to you that, and I've given you examples why the Supreme Court decision is going to result in practical absurdities. And one of the absurd situations I have just alluded to is the situation where the voice vote is taken. And at that point, the second deputy speaker, if he or she is the one in the chair, would not have taken part in the voice vote because he or she would normally be attentive. You want to know which of the voices, is it the ayes or the nays, which is more thunderous, and you call for them. Having not taken part, if there is controversy and somebody calls for a division, then you are saying that the same person who did not take part in the voice voting should now stand up to be counted.
Why is it that your standing orders has provided for in it that a committee chair, when there's a tie, can vote to make a decision, but a deputy speaker who is a member of parliament, when there's a tie, cannot vote to make a decision?
So that is the problem. And so straight away you would see that the procedure at committee sittings is slightly different, only to the extent that the chairman of a committee is given only a casting vote. But you see, the problem is that the second deputy or the first deputy speaker may have the right to vote if he or she is not in the chair. But as for the chairman of a committee, at all times when he's present, he or she would chair the proceedings of the committee.
Right.
And the standing order says, look, for purposes of neutrality, you want to be a neutral umpire. You should be unbiased in regulating the procedure, the debate at the level of the committee. Originally, don't vote. But when there is a tie, because we don't want Parliament's work to grind to a halt, because if there is a tie and you are unable to resolve the tie, either for or against, you stultify the work of Parliament. So let's give the casting vote to the chairman. But so the fundamental question is it also unconstitutional to deny the chairman the right to have an original vote? Is it also unconstitutional? And that is why I'm saying that the Supreme Court, in shooting down Order 1093, did not advert its mind to 211. If they had done so, I'm sure they would have had a change of mind. Because what the Supreme Court itself did not want to do, and you will see, when you read the judgment, you will see that they made it very clear that the only reason why they thought they had jurisdiction to deal with this matter of the first and second deputy speaker having the right to vote and be counted for purposes of quorum under 104, and the controversy surrounding 102 and its real meaning and effect, is because the operationalization of Standing Order 109 seems to be in breach, or was in breach, of the constitutional provisions I have alluded to. And that is why they assumed jurisdiction in the first place. So they were very clear that if the matter had revolved around only the standing orders and the customs of Parliament, they wouldn't have gone in there. They would have respected the fact that Parliament is master of its own rules.
What is the provision in Order 1093?
The provision is very clear. It says a deputy speaker or any other member presiding shall not retain his original vote while presiding. It's as simple as that. Original vote. No mention is made of casting vote here.
So in Parliament, when somebody calls for a division, what do you do?
Of course, when somebody calls for a division, it means that after the voice vote, there's no certainty with regards to which side should be declared as having won.
So
you can head count. Yes. So head count.
That's voting.
That is voting. The voice voting is also permissible.
Right.
Yeah. But one would the head count would put matters beyond doubt. If somebody gets up to call for a division, it means that look, he's not very sure. He wants to be sure that what the speaker has, the speaker's verdict in terms of having called the vote for the ayes or the noes is indeed true or not. That's it.
Now, Supreme Court has ruled on the matter. You are not comfortable with the decisions by the Supreme Court justices.
So you see,
what do you intend to do?
So you see, Justice. So you see, this evening, what you and I have been doing is to critique the judgment of the Supreme Court.
Right.
And I want to make it very clear that the Supreme Court or the judicial arm of government is not immune from criticism. So let's make that point very clear.
Criticisms.
It's not immune from criticism. Right? It's short of insulting the justices, impugning ill motives. We are entitled, you and I, after the Supreme Court has handed down its decision, to critique it. And that is what you and I are doing now. Now, I'm saying this against the background, the backdrop of some people attempting to malign others, including President Mahama, for criticizing the verdict of the Supreme Court.
In fact, even the deputy,
he said he was not surprised about the outcome. And why not? And why not? So if he says he was not surprised, why should people take him to the cleaners? He's a citizen of this country. The Supreme Court is not above reproach.
In his caliber as a former president.
It doesn't matter. It doesn't matter.
A dent on the judiciary.
Why?
Isn't it?
Why? Is it a dent? He's simply saying that you have handed down a decision.
He was
which doesn't sit well with me.
Judiciary.
If anybody says President Mahama mistrusts the judiciary, you should, it would be laughable, because this is the man, when the Supreme Court ruled against him in the presidential election petition, he simply said, I disagreed with your verdict, and then explain why he disagreed with the verdict of the Supreme Court, the failure of the court to hold G. Mensah to account, etc. But nevertheless went on to say, I respect the verdict of the Supreme Court, and call for calm amongst his followers. How can anybody turn around and say such a man, such a man does not respect the judiciary merely because he sounded critical of the judgment?
If somebody says, I'm not surprised of anybody's attitude.
Of course, because he was guided by previous decisions of the court, as in the presidential election petition case. So if the same court this time around has handled this matter in a manner that is not satisfactory to him, why can't he speak out in condemnation of the judgment of the court? You can't do so. It is within your rights to do so. So the attempt to create the impression that the judiciary is above reproach is reprehensible. That view can never stand the test of time. Nobody is above the law. Justice emanates from the people. So the judiciary exercises justice for and on behalf of the people. So if you exercise justice in a manner that doesn't sit well with some people, they are allowed to express their views. They are allowed to express their views. Remember here that nobody has insulted the judiciary. He just said, I'm not surprised. I disagree.
To see that
because you fail to hold A, B, C, D to account for her stewardship. These are statements that are permissible. Why do you think they are not statements that are permissible?
Parliament, the minority in Parliament. I recall vividly that you described the ruling as a travesty of parliamentary justice. The other time, Honorable Suhini was on this program, he described the ruling as a partisan ruling. In fact, the minority leader also described the ruling as a judicial, support for the approval of the e-levy. Are these ones not in a bad taste?
But, Justice, why would you say...
these criticisms?
Why, when you say it's a judicial... Look, you see, you must put these statements in their proper context.
What was...
Listen, what was the issue before the Supreme Court? Some of the issues had to do with the passage or otherwise the passage of the budget. The budget policy statement.
Right.
And that policy statement clearly contained the proposals for the e-levy. Now, read the judgment of the Supreme Court. The controversy had to do with whether or not the first deputy speaker, in taking the decision to count himself for purposes of quorum, when they set aside the earlier decision of Parliament to reject the budget, he was working within the remit of the Constitution or not. So the Supreme Court said yes. They found that yes, what he did was proper. And if that was proper, it means that the passage of the policy statement had been endorsed. Was that not an endorsement of the policy statement which had earlier been shut down?
An interpretation of the Supreme Court.
Of course, yes. So if
the power to interpret
exactly, so if the minority says that, oh, what has happened is judicial endorsement of e-levy, what's wrong with that if you put the statement in proper context?
Support.
What's wrong with that?
Judicial support for the approval of e-levy.
What is wrong with that? Because that decision,
in effect, are you not
that decision put matters beyond doubt.
In effect,
but for that decision, listen, there were two competing decisions. What the minority side did after the majority had staged a walkout. Remember that the budget was clearly shut down. Subsequent to that, they came back and with the help of the first deputy speaker, because he counted himself, set aside the earlier decision taken by the same house. So there were two competing decisions here. Right? Now, the Supreme Court exercised its power of interpretation and came to the conclusion that the budget was duly passed. Was that not a judicial function? Interpretation, is it not a judicial function?
Right.
So if the minority leader says what happened was judicial endorsement of e-levy, because e-levy was one of the main reasons why we fought the budget so hard. So you see, if you don't put things in their proper context, you can take things out of context and interpret them in a manner that would create problems for everybody.
What is your justification for a colleague of yours here on this platform describing the ruling as a partisan ruling?
Well, I haven't heard that. My colleague was here.
Yes.
And made such statements. I'm sure you had the opportunity to have a conversation like we're having now. So why do you want me to speak for my colleague? Because in any case, the minority has a common position.
It appears
the minority has a common position. Our position is that we disagree with the verdict of the Supreme Court, and that verdict is a major setback.
Is judicial support for the approval of the e-levy not similar to a partisan decision taken by the Supreme Court justices?
So when we say partisan, in what context are you using the phrase or word partisan? I don't understand. I don't understand, and I wouldn't know the particular context, right, within which my colleague used the phrase or word. You are in a better position to say. But all I can tell you is that the minority's position is that we are very much aggrieved with the verdict of the Supreme Court. And you've heard others urge the plaintiff to go for a review.
Right.
Yes, to go for a review.
Apart from
it's unfortunate. Parliament as an institution.
You have espoused on some of the confusions this is likely to create in Parliament. I mean, by implication, you are saying that the decision by the Supreme Court justices would mean that you can refer to a deputy speaker as an ordinary member of Parliament once they have said that he is a member of Parliament and has the right to vote.
Yeah. So
how are you going to deal with those issues in Parliament?
Well, there are challenges. Now there are challenges that we would have to, I don't know how to put it, find a way of surmounting. Because definitely there's going to be a challenge with order in the House when a deputy speaker is in the chair. Because it will take a lot of effort to convince members that the deputy speaker sitting there can exercise all the rights of the ordinary member sitting in his chair, assigned to him by the whip. All right? And that while sitting there, you can exercise all those rights, including even descending into the arena of debate. And I've established why that is a possibility in light of the ruling. If that happens, it may be difficult for the first and second deputy speaker to maintain order in the House. Because some members may simply just want to resist them. And if they do, you see the smooth running of Parliament is going to suffer in the process. And that is why I'm saying that the Supreme Court did not help matters. They ought to have given meaning to the time-tested principles espoused in for an Attorney General, when Justice Sowa said that it is not for the courts to inquire or seek to inquire what goes on in Parliament. And whatever happens in Parliament is a closed book.
Right.
You see? But now we've opened a can of worms. The courts have made it very clear that they can now descend into the legislative arena and determine, what decisions are right or wrong. Okay, so there is an incursion. No two ways about that. But of course, the court is also insisting that it has the power to interpret the Constitution. So it's quite confusing, and in as much as we respect the decision of the Supreme Court, we also know that there are going to be some practical difficulties in Parliament. The Supreme Court has done its part, but the problem is that we are going to have serious practical difficulties in Parliament, and that is my worry.
By Article 110, Standing Orders of Parliament, subject to the provisions of this Constitution, Parliament may by standing orders regulate its own procedure. You think that Order 1093 has not contravened any provision in the Constitution? The Supreme Court, that is supposed to be a co-equal of the legislature, the judiciary that's supposed to be a co-equal of the legislature, has expunged that order in your standing orders. Is this something you contest as a House?
Well, we contest as a House. All I'm saying is that, listen, the Supreme Court took the view that any attempt to seek cover under a political question doctrine in our country under our constitutional dispensation will not wash. But I'm saying that if we had pondered over the issue a bit, and what does that mean? It simply means that we should water down on principles like separation of powers, etc., which requires that the various arms of government should see themselves as co-equal branches and all that. But with this decision, clearly we're saying that, listen, the branches of government may not be co-equal. That is what it means. They may not be co-equal after all. So the question that came up for determination also had something to do with matters that had actually happened, with the clear application of procedures, internal procedures, etc.
Right.
But somehow constitutional provisions also, came in to play. So the court says, in view of the fact that there were some constitutional provisions which needed to be interpreted because the parties themselves largely agreed that there was a matter for interpretation, they would make an incursion into parliamentary procedure and determine whether what Parliament has adopted in the form of standing orders for itself since 92 should be shut down or not. The end result is that Standing Order 1093 was shut down. Then I asked the question, how about 211, Standing Order 211, which is in respect of a chairman of a committee not having an original vote but can only exercise a casting vote when there is a tie? How about that provision? Is it also unconstitutional? I thought the Supreme Court should have given us guidance. You see, so the point I'm making is that it appears the Supreme Court did not take full account of the standing orders in its entirety and to determine whether the application of the standing orders has served Parliament well for the past 30 years or not, in arriving at the decision that they arrived at. Because in one breath now we're saying that, okay, 211 stands. Why? How can you convince me that the chairman of a committee can be denied his right to exercise an original vote, but when you are presiding, no, you must enjoy the right to vote, and in fact to be counted for purposes of quorum. But under 102, when it is about quorum for commencement of business, that same person cannot be counted. What type of logic is that? But of course, that is the reasoning of the Supreme Court, and we have to accept that. That is the law for now. But I'm saying that this would create practical difficulties for Parliament as an institution.
Well, before we go, we've seen the problems this is likely to create, but what should be the way forward?
Well, for now, I would say, and I've made the point, that Parliament as an institution is going to be hit with practical difficulties, especially when the deputy speakers are in the chair. So moving forward, I don't know whether it's the Constitution which has to be amended. I don't know. Maybe some have advocated for the position of deputy speakers. Maybe we should do away with that position and allow some technocrat, maybe the clerk to Parliament, or somebody who is also not a member of Parliament, to occupy that position. Maybe if we did that, all the challenges we are having now wouldn't even arise, so that we all know that the second deputy speaker is brought from outside Parliament. So when he or she is in the chair, there would be no argument whatsoever on the question of that person attempting to assert voting rights. So maybe that could be a solution, but that would require an amendment to the Constitution as it stands.
Right. Thank you so much for coming. We are so grateful for your time. Your final words.
Well, Justice, I would say that we need to be tolerant, especially when it is about criticizing judicial decisions. The judiciary cannot be immune to criticism.
Not beyond
but
reproach.
let the criticism be constructive.
Right. All right, thank you so much, Honorable. I'm so grateful for your time. This whole time will allow us on the program. Make a time with us, same time tomorrow. Tomorrow we are discussing the hike in fuel prices. I hope by now you know that diesel at Total is now 10 cedi, 80 pesos per liter. And I mean, the petrol is somewhere around 9 point something per liter. Tomorrow, we shall see what might have been contributing to some of these things. Is it possible that by the end of this year, we may be buying, diesel and petrol at the pump at 20 Ghana cedis or something? The way and manner the prices are flying of late. We'll come and delve into that deeper tomorrow on this platform. Make a time with us, same time tomorrow. My name is Justice Appiah. The show has been Hot News. Goodbye.